Now I am moving to the previous year questions which ask from the constitution area, that is political area, that is polity, that is constitution governance area. For your easy understanding, the question from 2022 till the first part, we made a first part based on different theme areas, different themes which we separated. We separated question from right to duties, right and duties. Then we separated questions which is asked in judicial area, judiciary. We separated questions which is asked from the legislative area, that is regarding parliament and the state. We separated question which is asked from the constitutional bodies and non-constitutional bodies. So that is the way we framed our previous year questions for your easy understanding of each topic. So now we are moving to the discussion of PYQ, that is called the previous year questions. And the first core theme, that is A, we are talking about right and duties, which is totally connected with the fundamental rights and the fundamental duties of the Indian Constitution. And if you look at the first question that the UPSC asked, the question was a legislation which confer on the executive or the administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violate on the following articles of the Constitution of India. Option A, it is saying Article 40. Option B, Article 28. Option C, Article 32. Option D, Article 44. Here, by looking this question, you may feel that it is very lengthy question, and by reading first time you may not understand this what it is explaining. But first of all, if you look at the option itself, you can eliminate option D and option B, because option B, Article 28, which is talking about cultural and educational right, cultural and educational rights, that is Article 29 and Article 30, which is talk about cultural and educational right. So by reading this statement itself, I understand it is not talk about Article 28. And Article 44, that is talk about Uniform Civil Code, that is one of the DPSP of Indian Constitution, Directive Principle of State Policy. So option B and option D is eliminated. Then the remaining is option A, what is called Article 40 and Article 32. The point here that this question is says a legislation which confer executive administration authority and unguided and uncontrolled discretionary power in matter of application of law violate the which of the following articles of the Indian Constitution. We know that Article 40, which is talk about equality before law, equality before law and equal protection of law. Equality before law, it means all are equal in front of the law. The king is not above the law, king is below the law. So it means unguided controlled, that is against the equality. So the answer should be A for Agra. Article 14 means there is a rule of law that everyone should be treated equally. There cannot be any sort of power to some people can force on them. That is unguided power. That is the violation of Article 40 of the Indian Constitution. So first question answer is A for Agra. Second, under the Indian Constitution, concentration of wealth, it is violates. Option A, right to equality. Option B, DPSP. Option C, right to freedom. Option D, concept of welfare. Many people may confused between option B and D. You know that wealth, which is talk about a socio-economic principle, that is part of the DPSP of the Indian Constitution. So the wealth violate means under the Indian Constitution, concentration of wealth, that is Article 39B and Article 39C of the Indian Constitution. Article 39B, which says that concentration of material resources. Article 39B says that the resources should be shared to the citizen. Material resources should be shared. And C says that concentration of wealth cannot be concentrated to a person only. It cannot be concentrated to a single person. So 39B and 39C of the Indian Constitution is tried to establish a socio-economic principle. And by Article 39B and C, the Constitution tried to eliminate the inequality in our society. If you remember, our first Prime Minister Pandit Jawaharlal Nehru, whose pet project was Samadari Abolishment Act and Land Reforms Act. By abolishing the Samadaris and when conducting land reforms, he tried to create a welfare state. So answer should be a B for Bombay. Concentration of wealth, that is part of Article 39B and C of the Constitution. Like recently, the inequality report, which is published by the Oxfam International, also says that the 90% of Indian resources is concentrated in 10% people in India. So what we can say that the socio-economic or the socialism principle that is mentioned in our preamble is till now we not achieved. The inequality between the rich and the poor in our society is getting wider. So the two answer is a B for Bombay. And now the question number 3, right to property. I already explained to you right to property, original constitution, it was our fundamental rights under Article 90 and 31 of the Indian Constitution. But because of 44th Constitution Amendment, it was omitted to Article 300A of the Indian Constitution. And I already told you it is a constitutional right, it is a legal right, and it is a human right also. This was a judgment given by the Supreme Court of India. So the answer should be, it will give you, you must study when you are doing previous year question paper, you must study elimination techniques also. Look at option A. Option A says legal right available to citizen only. Legal right available to citizen only. If you look on the state, you can see two types of people. One citizen and other is non-citizen. Non-citizen also we can divide it into two: friendly alliance and enemy. So it is option A says that legal right available to citizen only. We can't say completely that the right to property is given to the citizen only way. So option A should be eliminated. And if you look on option C, fundamental rights available to citizen only, that also wrong. Already I explained you it was fundamental duty, but fundamental rights, but it is not a fundamental rights right now. So A is eliminated, C is eliminated, and D says that neither fundamental rights nor legal right. I already told you it is a legal right. So D is eliminated. So answer is B, legal right available to any person. Any person, it means in the constitution, person, it can be a man or a company or etc. Company also can be properties. So that is a wider interpretation, persons. Recently there are judgments regarding persons. So answer is a B for Bombay. 4. Right to privacy is protected under which of the articles of the Indian Constitution? The right to privacy, while you are preparing, you should remember about K.S. Puttaswamy case. K.S. Puttaswamy case, the Supreme Court of India, which given the right to privacy is part of Article 21 of the Indian Constitution. So answer is C for Calcutta. This question can ask you in a different way in the upcoming prelims. The right to privacy was recently in news. It's referred to option A, right to equality, option B, right to freedom, option C, constitutional right, option D, legal right. So answer should be B for Bombay, right to freedom. That is in the fundamental rights, Article 90 to 22, which is talk about right to freedom. Article 21, which is giving you right to life and liberty, except there is a procedure established by the law. So the right to privacy is one of the right under right to freedom, because our fundamental rights are divided based on different. Means Article 40 to 80 we divided or we classified into right to equality, which is ensure the equality in the society. Article 90 to 22, which is talk about freedom. 23 and 24, which talk about exploitation. Article 25 to 28, which is talk about right to freedom of religion. And 29 and 30, which is talk about cultural and educational right. And Article 32, that is called constitutional remedies. So the right to privacy, that is part of right to freedom under Article 21 of the Indian Constitution. So the 4 answer is C for Calcutta. 5. Which of the following factors constitute the best safeguard of the liberty in the liberal democracy? Option A, committed judiciary. Option B, centralization of powers. Option C, elected government. Option D, separation of powers. If you look onto this question, like I already told you, if you try to eliminate the options, if you look on this question, you can see best safeguard of liberty in the liberal democracy. Centralization of power is against the liberty in the liberal democracy. Centralization of power. We know that in our system of we follow decentralization. We have a 3-tier system, which we have in the central level we have a union government, and they have a union legislature, what is called the parliament, which consists of president, Lok Sabha and the Rajya Sabha. When it comes to the state, we have a chief minister, which is headed by the state, and we have a state assemblies, and also we have a one more tier, that is called the Panchayati Raj system. So decentralization, that is ensure the liberty, not centralization. So option B can be elected. And if you look on the C, elected government, we can't say that 100% surety that elected government will ensure liberty in the liberal democracy. We have examples of Article 352 and 356 in our country. The Indira Gandhi, who used emergency in 1971 till 1978, and India seen 3 emergencies: national emergency in 1962 till 1967, then 1971 second emergency, then 1975 third emergency, and in the many states we seen a presidential rule. So we can't say that a elected government ensure your liberal elected government ensure a liberal democracy. So option C can be eliminated. Then separation of power. The separation of power, it means legislator or legislative, executive and judiciary. That is called separation of power. It means there is a wall of separation in the democracy system, that the legislative, their duty to creation of law, executive, their duty is to implementation of law, judiciary, their duty is to check and balance. But by that also we can't say that best safeguard of our liberty. It will ensure a group work. So we can't say that complete safeguard of liberty. The complete safeguard of liberty, we can say that a committed judiciary. The independent judiciary will ensure a personal liberty, right to marry someone, Hadia case, right to privacy, right to internet. These are the examples of a liberal democracy. Right to travel abroad, right to travel inside, right against handcuffing, right against telephonic conversation, right to right for RTI, right to host national flag. These all are part of a liberal democracy. To ensure that liberty, we need a committed judiciary. So committed judiciary will ensure the people liberty. So answer should be A for Agra.
So the sixth question, which of the following category of fundamental rights incorporate protection against untouchability as a form of discrimination? We know that the fundamental rights are categorized into uh, fundamental rights are categorized into equality, freedom, right against exploitation, right to religion, cultural and educational right, and constitutional remedies. We know that equality, that is starting from Article 40 to 18, then freedom, that is 90 to 22, right against exploitation, that is Article 23 and 24, right to freedom of religion, that is 25 to 28, then cultural and educational right 29 and 30, and constitutional remedies is Article 32 of the Indian Constitution. If you look on here, this question is asking which of the following fundamental rights incorporate protection against untouchability. So the answer is D for Delhi, that is right to equality. That is Article 40 to 18. That if you look on Article 40 to 18, Article 40 of the Indian Constitution says right to equality before law and equal protection of law. Article 50, it says that you cannot be discriminated based on caste, race, religion, sex, place of birth. Article 60, that you cannot be discriminated on public employment based on seven criteria, that is 5 plus 2, that is descent and residence. Then Article 70, it's giving you right against untouchability, and Article 80, right against titles. But if you look on this Article 70, what is called untouchability, here one more point that I want to add you here, that we know that when we studied fundamental rights, we studied that fundamental rights is not absolute in nature. It can be cut down by the parliament, and there can be a reasonable restriction on our fundamental rights. But the point here I am trying to raise here, that two fundamental rights into our constitution is completely absolute in nature. That is, one is Article 70, that is untouchability, right against untouchability, that is absolute in nature. Then Article 23 of the Indian Constitution, that is right against exploitation. These two fundamental rights in our these two articles in our fundamental rights are absolute in nature. So answer is D for Delhi, right to equality. 7. Other than fundamental rights, which of the following parts of the Constitution India reflects the principles of the provisions of Universal Declaration of Human Rights? We know that the human rights are the right that we have simply because we exist as a human beings. Every year, December 10, we celebrate World Human Rights Day to commemorate the day of the United Nations General Assembly adopted the Universal Declaration of Human Rights. So the point here I am trying to add on that, if you try to compare the Universal Declaration of Human Rights and the Indian Constitution, the Universal Declaration of Human Rights, which is enacted in 1948, and Indian Constitution were enacted in 1950 January 26. So both at the same time we can mention. So there are some principles of universal human right can see in our constitution. If you look on the preamble which says that justice, liberty, equality, fraternity, that all are the principles of universal declarations, part of the universal declaration. Then the fundamental rights also talked about equality, then right against exploitation, then freedom of religion, that also part of the universal declaration in the fundamental rights part. But in the DPSP also there is a article like article 39B and C, which is ensure the socio-economic principles in our constitution. Then there are bill which is passed by the parliament to enact the DPSP principle like Mahatma Gandhi National Rural Employment Guarantee Act, Maternity Benefit Bill, Wildlife Protection Act, Environment Protection Act. These all are the examples of implementation of DPSP. At the same time, these principles are also mentioned at the Universal Declaration of Human Rights. Then in the fundamental duty also there are duties which is mentioned in the Universal Declaration for the citizen as well as the non-citizen which is staying in a state. So they are also in the Indian Constitution by 42nd Constitution Amendment Act, which is added a new chapter to our Constitution called the Fundamental Duty. And in the initially it was 10 duties, but in the 86th Constitution Amendment, which is added one more duty into our fundamental duties. So these three which is are visible in the Universal Declaration of Human Rights, answer is D for Delhi. And 8. Which of the following Constitution of India safeguard one right to marry persons one choice? This was recently also current affairs because of a case known as Hadia case. Answer is B for Bombay. We know that Article 21 is talk about right to right to life and liberty except there is a procedure established by the law. The point here you should understand that if you try to compare between fundamental rights and human rights, we know that all fundamental rights are human rights, but all human rights are not fundamental rights. We can say fundamental rights is a subset of a human rights. But in Manava Gandhi case onwards, 1978 onwards, the Supreme Court of India started to expand the scope of Article 21. The most of our human rights were integrated to our fundamental rights by Article 21. The right to travel abroad is a fundamental right. Right to bear a child is a fundamental right. Right to privacy is a fundamental right. A right to marry someone is a fundamental right. So the Supreme Court of India used Article 21 to expand the life and liberty of the citizen. So answer is B for Bombay. 9. As per the recent amendment to the Indian Forest Act 1927, the forest dwellers have the right to fell the bamboos grown on the forest area. The first option that is wrong because the Indian Forest Amendment Bill 2080 permit felling and transit the bamboos grown in the non-forest area. However, the bamboo grown on that forest land would continue as per that law to classify it as a tree. And first statement that is wrong because it is not a Indian Forest Act of 1927. It is Indian Forest Amendment Bill of 2080 which is given that right. Second statement that is correct as per the uh, as per the Scheduled Tribes and other traditional forest dwellers of Forest Right Act 2006, bamboo is a minor forest produce. Yes, that is correct because it waived with the right of ownership, access and collect, use the dispose of minor forest produce with the Scheduled Tribes and traditional forest dwellers. And 2006 Act which recognized the bamboo as a minor forest produce. So second statement that is correct, and the third also that also statement is correct that I already explained you in the in 2006 the Forest Right Act for the first time defined. I repeat, in 2006 the Forest Right Act for the first time defined minor forest produce as including bamboo and other products, and it also give traditional it also give the tribunal and other traditional forest dwellers the right to ownership, access to collect, use and dispose of minor forest produce which has been traditionally collected within or outside the village country. So the second and the third statement that is correct, the forest right, which is Forest Developers Organization of Forest Right Act 2006, which allows the ownership of minor forest produce to the forest owners. So 2 and 3 is correct. Answer is B for Bombay. Please remember the first statement, that is not the Indian Forest Act 1927 which is giving them the right. That is Indian Forest Amendment Bill 2008, 2018, which is giving permit the felling and transit of bamboos grown in the non-forest areas. So that about the answer 9. Answer is B for Bombay. 10. Right to privacy is protected as an intrinsic part of right to life and liberty, which are the following in the Constitution of India correctly, appropriately implies the above statement. Couple of years right now, in I think in 3 or 4 years, almost 2 times the UPSC which asked right to privacy question. In the initially it was asked right to privacy is related to which of the following cases, that is case Puttusamy versus Union of India case. Then right to privacy is part of which of the article, that is article 21. And this is the third question that I seen, that right to privacy is protected intrinsic part of right to life and personal liberty, which are the following in the Constitution of India correctly, appropriately employ the above statement, that is Article 21 and freedom guaranteed part 3 of the Constitution. Right to privacy, that is part of Article 21 of the Indian Constitution. Every year there will be a question from Article 21. Then 11, which of the following are envisaged by the right against exploitation in the Constitution of India? First statement, prohibition or trafficking in the human beings and forced labor, that is right against exploitation. Abolishment of untouchability, that is right to equality, not right against exploitation, right to equality. So you can eliminate option 2. Option 2 eliminated, A is eliminated, B is eliminated, and D is eliminated. The protection of interest of minorities, that is right to or cultural and educational right, and provision of employment of children in factories and mines, is that is correct, article 24 of the Indian Constitution. Answer is C for Calcutta. You just look, we only, if you know at least one statement, that is abolishment of untouchability, you are 100% know that it is not right against exploitation, that is part of right to equality. Just eliminate option B, sorry, not option B, option 2 is eliminated. You can easily get into the answer, that A is eliminated, B is eliminated, answer D is eliminated, C for Calcutta. So right to vote to be elected in India, there are confusion. Right to vote is whether it is constitutional right or legal right. So as per the UPSC key, it is a legal right. The UPSC which is said that right to vote is not a constitutional right. We know that right to vote, that is mentioned article 326 of the Indian Constitution. But the UPSC in the different cases, the Supreme Court of India said that right to vote is a legal right. So answer is, as per the UPSC key, answer is D for Delhi, legal right. 30. In the context of India, which of the following is the correct relationship between rights and duties? Rights and duties. Right are correlative with the duties. B. Right are personal and hence independence of society and the duties. Right, not duties, are important for the advancement of the personality of the citizen. Duty, not the rights, are important for the stability of the state. Answer is A for Agra. If you look on the second option, third and option D, we can easily eliminate those. Right are personal and hence independent of society and duties. We can't say that right are personal. It is based on the community also. The right, not duties, are important. Both are important because these question are framed. It is because of different importance of rights and the duties. We can say that the right and duties cannot be separated. When you have the right, at the same time you have the duty towards the state. So answer is A for Agra. 40. Which of the following implication of equality in the society is absence of? One of the implication of equality in the society in the absence of. Answer is B. Restraint. So it is a philosophical type question which is say that we if you want equality there cannot be sort of restraints on the. So 14 answer is a B for Bombay. 50. Which of the following statement is correct? Right are claims of the state against the citizen. Right are privileges which are incorporated in the Constitution of India. Right are claims of the citizen against the state. Right are privileges of few citizens against the many. You just look at option D. Right are privileges of few citizens. So option D is eliminated. Right or claim of the state against the citizen. Right, fundamental rights is for the people. So the people to the state which is saying that you should respect our liberty. That's why fundamental rights in our constitution is said to be negative, because fundamental rights which restrict the state from interfere the personal liberty of the citizen. So option A also eliminated. So answer is right, and okay, please look on option B. Right are privileges which are incorporated in the constitution of the state. Answer is C for Calcutta. Right are claims of the citizen against the state. That is correct. Fundamental rights in our constitution is said to be negative. It is only because right is to the citizen against the state. Whenever the state is interfering the right of the citizen, the Supreme Court of India will enforce that rights. So that's why answer is C for Calcutta. So 50 answer is C for Calcutta. Now we are moving to the core theme B, uh, which we talked about key features of the constitution. So in this theme, what we included that those questions the UPSC asked from the preamble DPSP in the previous years. So this is a core theme B, that this session is completely based on the questions from preamble DPSP etc. topics. So we are moving to that. Please look on the first question. What was the extract of constitutional status of India in the 26th January 1950? When you are seeing this question, you should analyze the question. The UPSC is demanding what is called the 42nd Constitution Amendment. We know that 42nd Constitution Amendment is known as a mini constitution, and we know that in the why 42nd Constitution the preamble got amended. The word called secularism and socialism, which added to our preamble. So it means originally these two words were not mentioned into our preamble. It means the when the constitution was enacted, the 26th January 1950, these two words were not there in the constitution. It is added by 42nd Constitution Amendment Act. So by knowing this knowledge, you can eliminate the options. Look at here, option C, secular democratic republic. So this option is wrong. Here look, socialist secular democratic republic. That also wrong. So C and D is eliminated. Answer should be B for Bombay. A sovereign, a democratic republic. The Indian Constitution preamble says that Indian Constitution is sovereign, socialist, secular, democratic, and republic. Here, secularism and socialism, which is added to the constitution by 42nd Constitution Amendment Act, and it is known as mini constitution. The 42nd Constitution Amendment Act is known as the mini constitution. So one answer is B for Bombay. Two, two. Here also we try to give you some techniques to solve the UPSC questions. Look at here. A citizen by birth only can become the head of the state. Head of the state, it means we have a two powers or a two executive bodies. One is called de jure and de facto. De jure, it means by power, by paper, the president is the head of the state. De facto, that is original power. De jure, that is the president, that is a head of the state, and de facto, that is prime minister, is the head of the government. So the question is about the head of the state means president election. It says that a citizen by birth only can become the head of the state. That is wrong. That is the American constitution is saying. In America, if somebody want to become the president of America, he should be a citizen by birth there. Other people who got the American citizenship by registration, naturalization, descent, he can't contest for the American election. But in India, the only qualification which is universal, that is called you should be a citizen of India. So only the way they use this statement is wrong. Second statement is wrong. You can eliminate two in B and D. And here third statement, a foreigner once granted citizenship cannot be, that also wrong, can be. A foreigner, he got the Indian citizenship, but within 5 years, if you are in the jail or he disrespect the constitution, there are following points. There are points which it says in the constitution. In the 5 years, if he is in the jail, his citizenship can be cancelled. So cannot be, that is an extreme word. So you can eliminate option 3 also. The C is eliminated. So answer is A for Agra. That is, there is only one citizenship and one domicile. But here I am adding the current affairs here that recently the Supreme Court of India said that there is no such domicileship. You only have a one citizenship, that is called the Indian citizenship. That was the recent current affairs of 1 year back. So true answer is A for Agra. Third, which part of the Constitution of India declared the ideal of welfare state? Answer is A for Agra. We know that the welfare state, it means we have a fundamental rights at part 3 of the Constitution, and DPSP is part 4 of the Constitution. The DPSP said to be positive and fundamental rights are said to be negative. The DPSP, which is asking the state to perform its duties by looking the culture, looking at the society to make law for the enactment of DPSP. By enactment of DPSP, the state is trying to ensure the welfare state. The state is trying to reduce the inequality between the rich and the poor. But the fundamental rights is said to be negative. It is because the state is completely restricted by the rights. So answer should be A for Agra. 4. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. The Constitution of India provides for judicial review to safeguard the citizen liberty and to preserve the ideals on which the Constitution is based. When you are looking this question, one of the important point I want to share you all, when you are solving UPSC exam, you should be concentration this word, the Constitution of India. The Constitution of India, the UPSC always begin with if they begin with the Constitution of India, you should be very much careful. It says the Constitution of India defined the basic structure. We know that the basic structure was recently in a news because in 1970 it was not an idea inside the Constitution. It was an idea which is innovated by the Supreme Court in the Keshavananda Bharatiya case. 2023 we are celebrating the 50th anniversary of Keshavananda Bharatiya case. So the Constitution of India is not defined what is called the basic structure. So one, that is wrong. It is an idea or it is an innovation of the Supreme Court to protect the Constitution values. So one is wrong. Second, the Constitution of India provides judicial review. Provides, that also wrong, because if you try to read our constitution, you can't clearly see what is called the judicial review in our constitution. If you try to analyze the constitution, you can only see the footmark of the judicial review in the constitution, especially article like article 30, article 32, article 226, article 142. These all are the article you can see the footprints of judicial review in the constitution. But the Constitution of India is not provide what is called the judicial review. So answer should be D for Delhi. The UPSC answer is D for Delhi. I hope you understand the difference or my explanation. The Constitution of India is not defined basic structure. At the same time, the Constitution is not directly providing what is called the judicial review. If you read the Constitution, we can see the footprints of judicial review in our Constitution. So, 4 answer is D for Delhi. 5. A common agreement between Gandhism and Marxism is A. The final goal of the stateless society. B. Class struggle. C. Abolishment of private property. D. Economic determination. So answer is A for Agra, that final goal of the stateless society. 6. The preamble to the Constitution of India is, we know that the preamble is the last part which is added to the Constitution. So it says that a part of the Constitution but has a no legal effect. Not part of the Constitution has no legal effect either. So option B is wrong, because in the Keshavananda Bharati case, the Supreme Court of India said that it is a part of the Constitution. So option B is wrong. C, a part of the Constitution has the same legal effect as any other part, that also wrong. Because in Beruvari case, Beruvari versus Union of India case, the Supreme Court of India said that preamble is the key to understand the mind of the lawmakers. So C, that also wrong. There is no such legal effect which is coming from the preamble. Option D, a part of the Constitution but has no legal effect independently for other parts. Option A, part of the Constitution but has no legal effect. Here the point you should understand that a part of the Constitution but has no legal effect, till there it is correct, but you should compare between the option A and D. A part of the Constitution but has no legal effect independently of other parts. That is correct. It is independently of other part but no such legal effect. So 6 answer is D for Delhi. 7. With a reference to the provisions contained in part 4 of the Constitution of India, which of the following statement are correct? They shall be enforceable by the courts. That is wrong. We know that the DPSP cannot be enforceable by the court of law. It is only be enforced by the parliament or the state assemblies. They only can enforce what is called the DPSP. They shall not be enforceable by any court. They shall not be enforceable in any court. Already the first statement says that they shall be enforceable by the court. That is wrong. They shall not be enforceable by any court. That is correct. The DPSP cannot be enforceable by any court. The principle laid down by this part are to influence the making of the law by the state. Yes. Answer is D for Delhi. If you look on the DPSP, DPSP is full form Directive Principles of State Policy. If you try to understand what is called the DPSP, it means it's saying these are principle. These are principle. It means Article 36 to 51, which is directing to the state whenever they are creating a policy. These should be keep on their mind. So the directive principle of state policy, which is commanding or which is telling the constitution which is telling to the state that whenever you are trying to create a policy, these principle article 36 to 51 should be keep on your mind while you are framing a policy for the state. So for the governance of the state, whenever a governance of the state, when the state want to enact a law, that should be from the DPSP. So 2 and 3 is correct answer is D for Delhi. 8. In India, separation of judiciary from the executive is enjoyed by, that is answer is again B for Bombay. Directive principle of state policy, that is article 50 of the Indian constitution, which is talk about separation of judiciary from the executive. 9. In the context of the polity, which of the following would you accept as the most appropriate definition of liberty? Protection against strictity of the political rulers, absence of restraint, opportunity to do whatever one likes, opportunity to develop oneself fully. Answer is B for Bombay. Absence of restraint. 10. The ninth schedule of the constitution was introduced in the constitution of India during time of prime ministership of. Answer is A for Agra. So the point here you should understand, the ninth schedule added to our constitution by first Constitution Amendment Act. So the ninth schedule which is added to article 31B, which is added by first Constitution Amendment Act during the tenure of our first Prime Minister Pandit Jawaharlal Nehru. So 10 answer is A for Agra. 11. Under which schedule of the Constitution of India can the transfer of tribal land to private party for mination declared null and void? That is 5th schedule of the Constitution. 11th answer is 5th schedule of the Constitution. 12. Under which of the following are regarded as the main features of rule of law? First statement, a limitation of power, equality before law, people responsibility to the government, liberty and civil rights. If you look on this, people responsibility to the government, look at this option. That is wrong. Option 3 is wrong. There is no people responsibility to the government, is responsible to the people. So if you know this statement, at least by looking this, you can eliminate option 3. So D is wrong, A is wrong. Then look at here, limitation of power, equality before law. So limitation of power, equality before law, liberty and civil rights, that is the correct answer. Rule of law. Limitation of power, the rule of law, it means all are equal in front of the law. The king is not above the law, king is below the law. That is called the rule of law. So limitation of power, there is no such privileged class. Everyone is equal in front of the law. Then equality before law. Then liberty and the civil rights. So answer is C, 1, 2 and 4. 30. Which of the following reflects the nicest appropriate relationship between law and liberty? Look at here. Option A. If there are more law, there is less liberty. If there are no law, there is no liberty. If there is a liberty, law have to be made by the people. And option D says, if a law are changed too often, liberty is in danger. So look at the first statement itself. If there are more law, there is less liberty. We can't say completely that if there is a more law, there will be a less liberty. So first statement, that is wrong. If there are no law, there is no liberty. If there are no law, there will be a more liberty. So that option also wrong. If there is a liberty, law have to be made by the people. Then look at the option D. If laws are changed too often, liberty in danger. So if there is a liberty, law have to be made by the people. That is correct. If there is a liberty, law have to be made by the people. So the 30 answer is C for Calcutta. 14. Consider the following statement. The Parliament of India can place particular law in the 9th schedule of the Constitution of India. That is correct. The Parliament, by passing law, they can put laws into the 9th schedule. Example, Samudari's Abolishment Act, Land Reforms Act. So recently, there are some states want to add laws into the 9th schedule. The validity of law placed in the 9th schedule cannot be examined by the court and no judgment can be made on it. That is wrong. This topic is very important for your upcoming preliminary exam also. The validity of law placed in the 9th schedule can be examined by the court after 1973 Keshavananda Bharati case. The Supreme Court of India said that the laws which is added after 1973 April 24 there will be a judicial review. So first statement that is correct. The second statement that is wrong. Answer is A for Agra. 50. Which of the following statement is a true of the fundamental duty of the Indian citizen? A legislative process has been provided to enforce these duties. Yes, the Parliament, if they want to enact the fundamental duties to the citizen right now, they can. But right now it is just a moral duties for us. There is no such forcing that the Parliament or the central government right now is not forcing us to practice our fundamental duty. But in the future, Parliament can provided to enforce these duties. Second, they are correlated to the legal duties. Yes. So answer should be C for Calcutta. 60. Which of the following objective is not embedded in the preamble to the Constitution of India? Liberty of thought and expression. Yes, that is correct. Liberty of expression. Liberty of belief. Yes. There is no such word called economic liberty. The preamble of the Indian Constitution which is ensure liberty of thought, expression and belief. You have the right to have a good thought. You can express your thought by different medias. At the same time, you have a liberty of belief. You can believe whichever the religion you want and you have the right to profess, practice or propagation also. So, but the economic liberty that is not mentioned in the preamble of the Constitution. So, answer should be B for Bombay. 70. The mind of the makers of the Constitution of India is reflected in which of the following? If you remember a couple of questions back, I already told you this word. The Union of India case, the Berubari versus Union of India case, the Supreme Court of India said that preamble is the key to understand the mind of the lawmakers. Answer is A for Agra. So, question number 18. Which principle among the following was added by the directive principle of state policy by 42nd Amendment Act, 42nd Constitution Amendment Act? We know that the 42nd Constitution Amendment Act, which is enacted in 1976, added no 4 directive principle to the original list. I can say Article 39, then Article 39A, then Article 43B, sorry, not 43B, 43A, then Article 48A. These are the 4 new directive principles which is added by 42nd Constitution Amendment Act. Article 39 which says that to secure the opportunity for healthy development of children, that is Article 39. 39A which is talked about to promote equal justice and to provide free legal aid to the poor. Article 43A, that is the correct answer in this question, that participation of workers in the management industries, that the state should take secure participation of workers in the management industry, that is Article 43A. And the new directive which is added by the 42nd Constitution Amendment, that Article 48A, to protect and improve the environment and to safeguard the forest and wildlife. So, 42nd Constitution Amendment which is added 4 new directive principles. So, answer is 18, answer is B for Bombay. And 90, the consider the following statement with the reference to Constitution of India, the directive principle of state policy constitute limitation upon. If you remember the last core theme when we discussed, I told you fundamental rights and DPSP. I said fundamental rights is negative and DPSP said to be positive. There I explain you fundamental rights is limiting the legislative as well as the executive from interfering the people liberty, the citizen liberty. So the fundamental rights is a limitation on government. But DPSP, that is a positive which is giving power to the state to enact policy that is beneficial for the poor or the beneficial for the society. We have a different laws which is enacted to support or to create a welfare state. So DPSP is not putting any sort of limitation on government, or there is no such limitation on legislative as well as executive. They can enact laws based on looking the society, their culture, diversity, etc. So answer should be a D for Delhi. Then question number 21 regarding amendments. We know that with the Article 32 which talk about writs. So Article 32 which is talk about 5 writs, we know that habeas corpus, mandamus, prohibition, censure, quo warranto. So the question is totally connected with the mandamus. So with the reference to the writ issued by the Court of India, consider the following statement. Mandamus will not lie against a private organization unless it is entrusted with the public duties. Yes, that is correct. Mandamus, it means we command, do your duties. The Supreme Court of India or the High Court, which is asking a public office to do their duty, that only can given to the public office. So first statement, that is correct. Mandamus will not lie against the private organization unless it is ensured with the public duty. That is correct. Second, mandamus will not lie against the company even though it may be a government company. So if you look on the second statement is incorrect. As I explained you above, the mandamus can be used against the government, corporation and or company. Here the statement says will not. So it can be, and mandamus can be used against government, corporation and or company. So second statement, that is wrong. Third, any public minded person can be petitioner to move the court to obtain the writ of quo warranto. So the statement third, that is correct. Quo warranto is issued by the court to inquire into the legality of the claim of the person to a public office. So it prevents that office to become a dictator or a authoritarian types. So unlike other writ, this can be sought by any interested person and not necessarily by that concerned person should be go for that. So any interested person can file quo warranto. So 20 answer is 1 and 3 is correct. Answer is C for Calcutta. So this is about our core theme B of our section regarding the polity previous year question paper analysis. Now we at the core theme that our theme C, that we talked about the questions related to executives. You just the first question, which of the following best define the term state? If you try to understand the definition of state, why we need a state, it means we need a state to create integrity and unity. So if you look on this concept by why we need a state, if you look on the statement option A, it says that a community of person permanently occupying a definite territory, independent of external control and possessing an organized government. And option B is saying a politically organized people. We can't say that a state you can see completely a politically organized people only. There are different ideology people, they are fighting each other. Like you can see different in Sri Lanka or different countries. You can see there is different ideologies, people are fighting each other. So a politically organized people, we can't give 100% that a state completely based on a politically organized people. So option B is wrong. C, a number of person who has been living in a definite territory for very long time with their own culture, tradition, and government. And that is if you look on the option C, that is a extreme statement that we can't accept that concept. And option D, a society permanently living in a definite territory with a central authority and an executive responsible to the central authority and an independent judiciary. If you try to understand the definition of state, I already eliminated option B. Here, in the political science, the term state has more specific and a definite meaning, the word state. It means a community or a society politically organized under one independent government with a definite territory. What I am trying to tell you all that if you try to study state, we can divide a state into territory, then sovereignty, and population and government. So if you try to understand the state, these four external elements like territory, sovereignty, population, and government, the first two elements constitute the physical or the material basis of the state, while the last two forms the political and spiritual basis. The state can define as a centralized, lawmaking and law enforcing a political sovereign institution in society. In other words, we can say it is a useful to understand the definite state in terms of functions in performs. But briefly and simply, the state comprises a set of institutions with ultimate control over the means of violence and cohesion within the given territory. So the answer should be A for Agra. A community of persons permanently occupying a definite territory independent of external control and possessing organized government. So one answer is A for Agra. And second question, with the reference to union government, consider the following statement. Gopalasamy Iyengar committee suggested that a minister and secretary be designated solely for pursuing the subject and administrative reforms and promoting it. And the second statement in 1970, the Department of Personnel was constituted on the recommendation of Administrative Reform Commission 1966 and it was placed under the Prime Minister in charge. So if you try to analysis, this is very we can't say that it is a completely easy type question, but it is morely related to the current affairs. Mostly we can say it is related to the current affairs because of 2021 there is a scheme which is introduced by the government called Karma Yogi. Mission Karma Yogi for civil service capacity building was launched in 2020. Based on these current affairs, the UPSC asked this question in 2021. Here, the first statement that is completely wrong. This committee called Gopalaswamy Iyengar Committee, in his report, namely talked about reorganization of the machinery of the central government. And in 1950, it recommended for grouping of ministers improvement in the capability of personnel and also in working of the ministry divisions. It nowhere mentioned that ministers and the secretary be designated solely for pursuing the subject of administrative reforms and promoting it. So the first statement that is completely wrong. This committee is not talk about the ministers and secretary be designated solely for pursuing the subject of administrative reforms and promoting it. So first statement that is wrong, but the second statement that is correct because in 1970 on the basis of recommendation of Administrative Reform Commission, the Department of Personnel was set up in the Cabinet Secretariat. And if you try to know more about that, it was placed under the Prime Minister's office. So second statement is correct. The first statement is wrong because there is no such uh, point is mentioned in the Gopalsamy Iyengar committee. So answer is B for Bombay. Third, which of the following in the Indian polity is external feature that indicate that it is federal in character? Option A, independent judiciary is safeguard. Option B, union legislators are elected representative from the constitutional unit. Option C, union cabinet has been elected representative from the regional party. Option D, fundamental rights are enforced by the court of law. The external feature that indicate the federal in character, that is answer is A for Agra. A, independence of judiciary is safeguard. We know that if you try to know the features of federalism, the first feature of federalism is a written constitution. Second is supremacy of the constitution. Third, rigidity of the constitution. Fourth, independent judiciary. And fifth, Supreme Court is guarantor and protector of the constitution. So by looking these 5 points, you can easily get the answer that independent judiciary, that is answer is A for Agra. The independent judiciary is safeguard. There should be a separation of power, that is executive, legislative and the judiciary. So the Constitution of India that also ensure the independence of judiciary under different provisions in our constitution. So three answer is A for Agra. 4. A constitutional government means, a constitutional government, it means that if you try to know the what is called the constitution which is talk about how the people should be lived in the country. The constitution is talked about how the government should be worked, how the government should be make the laws in the country. So that is the importance of a constitution. It means constitution is well structured how the country should be moved. So it means it not giving a chance to the government to move a different way. So it means the constitution is putting a limited government. We can say because of fundamental rights the government is limited, because of parliament, because of question hour, zero hour, because of non-confidence motion, that all are mentioned in the Constitution of India. Because of those, the executive is limited. There is an article called Article 368 of the Indian Constitution which is talked about how the Constitution should be amended, and also we have an independent judiciary. So it means that because of offering these all in the Constitution, the government is limited. So a constitution government, it means a government limited by the terms of the constitution. Answer is 4, D for Delhi. 5. At the national level, the ministry is a nodal agency to ensure effective implementation of scheduled tribes and other traditional forest developers Organization Forest Act of 2006. Answer is D for Delhi, the Ministry of Tribal Affairs. And look at the question number 6. In the context of India, which of the following is the characteristic appropriate for the bureaucracy? It is easily option, you can easily come to the answer, that answer is D for Delhi, the agency of implementation of public policy. 7. A constitutional government by definition is the same question. If you try to compare question number 4 with the question number 7 also, a constitution government by definition, it is a repeated question. Question number 4, this it was asked in 2011, sorry, 2021, not 11. The this question number 4, it is asked in 2021, and question number 7, that is asked in 2019. So a constitution government by definition, the same answer. I think I don't want to explain you more. Answer is D for Delhi, limited government. 8. Consider the following statement. No criminal proceeding shall be initiated against the governor of the state in any court during his term of the office. The emoluments and allowance of the governor of the state shall not be diminished during his terms of the office. So 8 answer is C for Calcutta. And if you look on this first statement, we can say that the first statement is talk about article called Article 361 of the Indian Constitution. Article 361 of the Indian Constitution is talk about no criminal proceeding whatsoever shall be initiated or continued against the president or the governor of the state in any court during his terms of the office. So that is the first statement. So the no process of arrest or imprisonment of president or governor of the state shall issue from any court during his term of the office. So first statement, that is correct. And second statement, that is talk about Article 158 of the Indian Constitution. Because the governor shall not be a member of either house of the parliament or of a house of the legislature of any state specified in the first schedule. And if a member of either house of the parliament or a house of the legislature of any such state is appointed governor, he shall to be deemed to vacate his seat in that house on the date in which he entered upon his office as a governor. So it means governor shall not hold any other office of profit. And also Article 158, which is talk that the emoluments and allowance of the governor shall not be diminished during his terms of the office. So both statements are correct. Answer is C for Calcutta. So when you are preparing for this year prelims, this governor topic is very important for you. Because of recent days, we know that there are some states, they went to the Supreme Court against the action taken by the governor in that state. So because of that, the governor topic is very important, that you can refer in our website Manorama Yearbook Online.com. So 8 answer is C for Calcutta. 9. Out of the following statement, the principle underlying cabinet form of government. If you look on the option C, a mechanism of parliamentary democracy for ensuring collective responsibility of government to the people. That is correct answer. Cabinet form of government. That is the cabinet. They are collectively responsible to the parliament, and especially we can say that cabinet, they are collectively responsible to the Lok Sabha. So their action they are taking and all should be answered in the parliament, especially in the Lok Sabha. If the Lok Sabha vote against them, that is called a non-confidence, they must resign from that office, that the Prime Minister should submit his resignation to the President of India. So 9 answer is a C for Calcutta. 10. Democracy's superior virtue lies in the fact that it calls into activity, and simply that answer is A for Agra, that intelligence character of ordinary men and women. 11. The main advantage of parliamentary form of government is that option A, the executive and legislative work independently. We have a two form of government, that is called a presidential form of government, and it's called the parliamentary form. But if you try to analyze the first statement is talk about separation of power. If you try to analyze the where this system called the separation of power is in strong, we can say that is in the president form of government. So this option is wrong, because separation of power, it means we have a executive, we have a legislative, we have a judiciary. So the legislative, their duty is to creation of law, executive, their duty is to implementation of law, the judiciary, their duty is to check and balance. But when it comes to the parliamentary form of government, if you look on India as an example, we know that the executives, that is the prime minister, council of ministers, and all are members of the legislative also. So there is a interrelated relationship between legislative and executive when it comes to the parliamentary form. So we can't say that they both are working independently. So option A is wrong. B. It provides continuity of policy and is more efficient. We can't say that is a, if you look on the option B, it is a extreme statement. We can't say that there can be a continuity of policy and more efficient in the parliamentary system. There are times in our country also when the new government come, the government which stopped or they discontinued the program which was done by the last or the previous government. So B also you can eliminate it. The executive remain responsible to the legislator. That is correct, because executive, the action they taken in the country, they should be answerable to the legislator. That is, we can say in the parliament. There will be a question hour. There will be a 0 hour when the budget will be presented. There will be a question from the opposition. There will be a cut-off motions. When the constitution was enacted, there should be an opposition. So, by different types of institutions, different types of safeguard, the constitution is protecting. So, the executive is responsible to the legislator. So, answer is a C for Calcutta. 12. The Constitution of India. I already told you, when you are doing questions, when you are dealing with the UPSC, the word should be you must focused. This statement begins with the Constitution of India. So it says that Constitution of India classifies ministers into four ranks: Cabinet Minister, Minister of State with independent charge, Minister of State, and Deputy Minister. So this statement is wrong. The Constitution of India is not made such classification. So first statement, that is wrong. Second, total number of ministers in the Union Cabinet, including Prime Minister, shall not exceed 50% of total number of members in the Lok Sabha. That is correct. The 91st Constitution Amendment, the 91st Constitution Amendment which made this, the Constitution 91st Amendment Act 2003 made amendment in Article 75, and if you look on Article 75, we can say by this amendment, the total number of ministers, including Prime Minister, in the Council of Ministers shall not exceed the 50% of total strength of the Lok Sabha. I want to tell you one more important point. It can be changed in upcoming exam as the same statement, but they will rechange this Lok Sabha into Parliament. Like, suppose you just look this second statement. In the upcoming exam, the UPSC may give you same question but different way. The second statement may the UPSC will change like this: total number of the ministers in the Union Cabinet, including Prime Minister, shall not exceed 50% of total number of members in the Parliament. If they change the Lok Sabha into Parliament, that is wrong. Only say that the Council of Ministers shall not exceed 50% of strength of Lok Sabha. So please aware regarding this point. The Lok Sabha can be changed to the Parliament. If you ask me what is called the Parliament, under Article 79 of the Indian Constitution, Parliament is consist of President, Lok Sabha, and the Rajya Sabha. So there is a bigger term what is called the Parliament. So total answer is
B for Bombay. And the last question in this our core theme C called the executive. Consider the following statement. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the in the meeting of the Parliament of India. Second statement, according to the Constitution of India, the Attorney General of India submit its resignation when the government which appoint him resign. See, look at here, I already told you, according to the Constitution of India. So the answer of this question is D for Delhi. Because second statement, according to the Constitution of India, there is no such, the Constitution is not talk about like this. As per Article 76, the Attorney General shall hold the office during the pleasure of the President of India. When the President of India loses his pleasure, he will be thrown off, or he will give his resignation letter to the President of India. So there is no mention in the Indian Constitution of the need for him to submit his resignation when the government which appointed him resigned. And first statement that also wrong. The Attorney General of India is appointed by the President of India under Article 76 of the Indian Constitution, and he hold the office during the pleasure of the President. And if you try to analyze his office, in the performance of his duties, he has the right to audience in all court in India, as well as right to take part in the proceedings of the parliament without the right to vote. But the point here you should understand, the Solicitor General of India has no such privilege. So first statement is wrong, second statement also wrong, answer is D for Delhi. So this is about our core theme C, what is called the executive. So the last part of the first polity previous year question paper revision, the core theme we choose the judiciary. Look at here, the first question, with the reference to Indian judiciary, consider the following statement. Any retired any retired judge of any retired judge of Supreme Court of India can be called back to sit and act as Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. Second statement, the High Court in India has the power to review its own judgment as Supreme Court does. See, if you look on this statement, the question is which is asked in 2021. The current affairs regarding this question at that time, the Kerala High Court said that the High Court as a court of record would review their own records, and also recently the judges are take take their oath. So that was the current affairs during that time in 2021. And if you look at the first statement, the Chief Justice of India can request a retired judge of Supreme Court or a retired judge of High Court to act as a judge of Supreme Court for a temporary period, and he can do so only with the previous consent of the President of India, and also the person to be has to be appointed, such judge to be entitled the allowance as the President may determine. So the first statement is correct answer. And if you look on the second statement that I already explained to the current affairs regarding the Kerala High Court said that the High Courts as a record or the court of record would review their own records, means their own orders. So if you look on the statement 2, the Supreme Court of India has the power to review their own judgment as per the Constitution, though it is not bound by its previous decision and can depart from its interest of justice or a community welfare. As of court of record, a high court also has the power to review and correct its own judgment or order. So first question answer is C for Calcutta. Both statements are correct. Second, with the reference to India, consider the following. Judicial custody means as an accused is in a custody of the concerned magistrate and such accused is locked up in police station, not in jail. That is wrong. The first statement, that is wrong, because the provision for custody in India are governed by the section 167 of the Code of Criminal Procedure. The police custody means that the police has a physical custody of the accused, while judicial custody means an accused is in the custody of the concerned magistrate. In police custody, the accused is lodged in the police station lockup, while in the judicial custody, we can say he is locked up in the jail. So first statement, that is wrong, and second statement, during the judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. That is correct. During the judicial custody, the police officer in charge of this case is not allowed to interrogate the suspect. However, the court may allow to conduct the interrogations if it opinion that interrogation be necessary under the fact produced before the court. The point here you should understand, during the police custody, the police officer in charge of case may interrogate the suspect. So answer should be B for Bombay. The true answer is B for Bombay. 3. With the reference to India, consider the following statement. When a prisoner make out of sufficient case, parole cannot be denied to such prisoners because it becomes a matter of his right. Second statement, the state government have their own prisoners release on parole rule. So if you look on the first statement, we can say that is first statement that is completely incorrect, because parole cannot be claimed as a matter of right. Parole is a system of releasing prisoners with the suspension of the sentence. But we can't say that parole is like a right, like a constitution or a fundamental or a legal, like those. Parole may be denied to be a prisoner even when he make out of sufficient cause for the release on parole. Parole is to be granted only on sufficient cause, such as cases of severe illness or death of any member of the prisoner's family. The granting authority of the parole is the Deputy Home Secretary of the state government. So the first statement, that is incorrect. And if you look on the second statement, the state government have their own prisoners release on parole rule. That is correct. State government have their own prisoners, means prisoners or prison that is under the state list of the 7th schedule of the constitution. So the management and administration of prisoners fall exclusively in the domain of the state government and are governed by the Prisoners Act of 1894 and the Prisoners Manual of the respective state government. So second statement is correct. The first statement, that is wrong. So 3 again, answer is B for Bombay. 4. With the reference to Constitution of India, consider the following statement. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. That is wrong. In India, the High Courts also have the jurisdiction to declare any central law if it violates Constitution. So first statement, that wrong. Second, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. That also wrong. Can be called into the question. There are number of times. Recently there is a conflict between Parliament and the Supreme Court. The Parliament is not happy with the way the Supreme Court of India scrapped the 99th Constitution Amendment. So there are Constitution amendments which were scrapped, or we can say declared as a null and void by the Supreme Court of India, which they said that it is violation of basic structure doctrine. So 4 answer is D for Delhi. 5. With the reference to Constitution of India, prohibition or limitation or provision contained in ordinary law cannot act as a prohibitions or limitation on the constitutional power under Article 142. It would mean which one of the following? So answer of this question is B for Bombay. If you look on here, as per Article 144, The Supreme Court in exercise of its jurisdiction may pass such degree or make such orders as necessary for doing complete justice in any cause or matter pending before it. One of the important instance of application by Supreme Court of Article 142 was Union Carbide case. We know that that is related to the victims of Bhopal gas tragedy. In this judgment, the Supreme Court, while awarding the compensation to the victims, went to the extent of saying that to do complete justice, it would even override the law made by the Parliament by holding that provision or limitation or provisions contained in ordinary law cannot change or act as a provision or limitation on the constitutional power under Article 142. This was a statement of the Supreme Court of India placed itself above the law made by the Parliament or the legislator of the state. So, answer of this question 5 is B for Bombay. 6. Consider the following statement. The 44th Constitution of India introduced article placing the election of Prime Minister beyond judicial review. The Supreme Court of India struck down the 99th Constitution Amendment. 99th Amendment to the Constitution of India has been violating of independence of judiciary. See, the 99th Constitution Amendment was in news recently because of there is the new Vice President of India is not happy the way with the Supreme Court of India scrapped or sorry the Supreme Court of India declared the 99th Constitution Amendment is null and void because it is against the independence of judiciary. So continuously he says that the parliament, the basic structure doctrine which is violating the basic the sovereignty of the parliament. And second statement that is correct and the first statement that is wrong because it is not 44th Constitution Amendment which is giving or remove the authority of the Supreme Court to adjudicate the petition regarding elections of President, Vice President, Prime Minister and Speaker of Lok Sabha. It is 39th Amendment of Constitution. Okay, it is 39th Amendment of Constitution introduced that the elections of President, Vice President, Prime Minister beyond the judicial review, but it was declared as null and void in the later time. So first statement is wrong, second statement is correct, answer is again B for Bombay. 7. In India, judicial review implies the power of the judiciary to pronounce upon the constitutionality of law and the executive orders. Yes, that is answer. I already explained you what is called the judicial review. If you try to read the Indian Constitution, that I already told you that in the previous questions, that you can't see judicial review directly in the Constitution. But by reading the Constitution, you can see the footprints of judicial review in the Constitution under Article 12, sorry, not under Article 12, Article 30, Article 32 and Article 226, Article 142. These are articles we can say the footprints of judicial review. So 7 answer is A for Agra. 8. The motion to impeach Judge of Supreme Court of India cannot be rejected by the Speaker of Lok Sabha as per the Judges Inquiry Act 1968. That is wrong. It is their discretionary power. If there is a motion of removal of judges come in front of the Speaker or Chairman, they have a discretion power whether to accept or reject that removal motion. So first statement is wrong. You can eliminate option A and option D. The Constitution of India define and give details of what constitute incapacity and proved misbehavior of judges of Supreme Court of India. The details of the process of impeachment of judges of Supreme Court of India are given Judges Inquiry Act of 1968. If the motion for the impeachment of judges is taken up for voting, the law requires the motion to be backed by each houses of parliament and supported by majority of total membership of the house and by not less than 2/3 of total members of that house present and voting. So answer of this question is C for Calcutta. 3 and 4 is correct. Answer is C. 9. Consider the following statement. Pursuant to the report of H.N. Essential Committee, the Contempt of Court Act 1971 was passed. The Constitution of India empowers the Supreme Court and High Court to punish for contempt of themselves. The Constitution of India defines civil contempt and criminal contempt. If you look on here, the first statement that is correct. The committee was set up in 1961 under the chairman of late H.N. Essential. Then he was the additional Solicitor General. The committee made a comprehensive examination of the law and program relating to the contempt of court in the light of the position obtained in our own country and the various foreign countries. So first statement that is correct. And second statement that also correct, because the Supreme Court and High Court of India have been empowered with the power to penalize for the contempt of court under Article 129 and Article 215 of the Constitution of India. So both court can punish for the contempt. So second statement also correct. But if you look on the third statement, the Constitution of India defines civil contempt and the criminal contempt. That is wrong. The Constitution of India does not define civil contempt and the criminal contempt. And if you look on the option 4, in India, the parliament is vested with the power to make a law on contempt of court. That also correct. If you look on Article 142, Clause 2 of the Indian Constitution clearly states that the subject of provisions of any law made by this behalf by the Parliament, the Supreme Court shall have all and every power to make orders on the punishment of any contempt of itself. Thus, we can understand that the Parliament is vested with the power to make a law on contempt of court. There are laws which is passed for the civil contempt and the criminal contempt. So 3 is eliminated and rest of statement 1, statement 2 and statement 4 is correct. So answer is B for Bombay, 1, 2, 4. 10. The government law officers with reference to India consider the following statement. First statement, the government law officers and legal friends are recognized as advocate, but corporate lawyers and patient attorneys are excluded from recognition as advocates. If you look on the first statement, we can clearly say that is incorrect, because the corporate lawyers as well as the patent attorneys are too recognized as the lawyers, and there is no provision on their recognition as lawyers. So first statement that is wrong. And second statement, the Bar Council of India visits and inspects the universities, the law colleges in the country as part of its statutory functions of promoting legal education and laying down the standard in consultation with the universities in India and State Bar Council. And we know that the State Bar Council is a statutory body established under Section 4 of the Advocates Act of 1961 that regulate the legal practice and legal education in India. So the second statement that is correct, the first statement is wrong. Again, answer is B for Bombay. So by these questions, so we are ending the first part discussion of Polity previous year question paper or the question sets. So we will come with the other themes, which is including legislator part, the question from the parliament area. So that is our next core themes in this series. So I hope this will help you to prepare in the upcoming the prelims, which is conducted by the UPSC in May 28. So I hope it will beneficial for you to go through this video, and we will update more in our website Manorama Yearbook. You can visit there. There are lot of content which you can refer, and mock test which all are available there in our website. Thank you.